On May 2, 2025, Michigan driver Ron Doyle Glenn was charged with 8 traffic violations, including 5 civil infractions and 3 misdemeanor offenses. Under Michigan law, citizens who are charged with civil infractions can either pay a fee or request a hearing. However, criminal defendants are required to appear at a formal arraignment in court, even if they are only charged with a misdemeanor traffic offense. Mr. Glenn was scheduled for an arraignment for the misdemeanor offenses and a hearing for these civil infractions on June 6, 2025, but he failed to appear in court. Default judgments were issued for the civil infractions as permitted by Michigan law. However, courts cannot issue default judgments for criminal offenses. So, a so-called show cause hearing was scheduled for August 19, 2025 as required by Michigan Court Rule 6.615. A so-called show cause hearing is a court proceeding that occurs after a missed court date or another violation of a court order where the defendant is required to appear and explain why they missed the arraignment and why they shouldn't be held in contempt or face additional penalties. Mr. Glenn also was charged with 4 additional traffic offenses on May 21, 2025, 1 civil infraction and 3 misdemeanors, including a charge of driving with a suspended license. The arraignment was scheduled for the misdemeanor offenses on July 3, 2025, and Mr. Glenn did not appear. So, another show cause hearing was scheduled for July 28, 2025. A hearing was scheduled for the civil infraction on July 7, 2025, but Mr. Glenn once again failed to appear and a default judgment was issued on the charge. On July 28, 2025, Judge Shaw Perkins presided over the first scheduled show cause hearing in the virtual courtroom for the Michigan's 36th District Court in Detroit. Mr. Glenn appeared for this hearing over Zoom, and he was represented by attorney Phyllis Gahan Robinson.
Mr. Glenn, Rondell Glenn?
Yeah, man, I'm sitting out in the sun, buddy. I'm trying to grab me something to eat.
All right, don't drive in court.
I'm not going to be driving, buddy, when I'm in court, all right? Just call me.
No, listen, I'm not your buddy, okay? First of all, but at the end of the day, if you're driving right now, you're not supposed to be driving, okay?
Yeah, but how long am I going to be sitting here? I haven't spoken to no defense attorney.
I don't know how long you're going to be sitting there. You're waiting. If you came on time, you would have heard me. I said I'm going to try to get you out as fast as I can.
It's all good, man. Listen, it's all good.
Listen, don't cut me off. Are you driving your car right now?
I'm going to park my car, but man, I can't be sitting out in the sun.
I'm putting you out of the room.
Put me out of the room?
Yes, for driving in court. All right? Come back when you get in a safe location.
Attorney Gahan Robinson on behalf of Mr. Rondell Glenn. Mr. Glenn, please state your name for the record.
Mr. Rondell Glenn.
Your Honor, I don't know how many tickets that was you just read off. I only have 3 on my docket.
Yeah, Mr. Glenn doesn't have any respect for the court. I see he's exhibited disrespect for the court, and he's.
Wait a minute, hold on, wait a minute. What you talking about?
You wait a minute. You wait a minute.
I'm going to the judicial tender commission.
You wait a minute.
I don't want you to remove yourself from my case, bro.
Listen,
I'm 58
there
years
he
old.
is. That's the disrespect.
I don't know what it is about me and you, bro.
That's the disrespect.
Mr. Glenn, can you please be quiet for one? Mr. Glenn, as the attorney who's trying to help you, can you please be quiet for a moment? The first issue that you have is you should not be driving on Zoom. Park the car, please. You cannot drive on Zoom. This is the definition of distracted driving.
He should not be driving at all. He's already indicated to the court that he's driving when he was driving while in court. I asked Mr. Glenn that if he's driving, he said he's driving and going to get something to eat, I believe. So now
Mr. Glenn wasn't driving. Somebody was driving for me. I'm with somebody. What do you mean? What do you mean, man?
I'm going to order Mr. Glenn.
I'm 58 years old, bro.
Mr. Glenn, I'm trying to help you. Can you please just wait a minute?
All these tickets from 20 years ago when it's only 3. You know what I'm saying?
Sir, stop. Mr. Glenn, stop so I can help you. I'm trying my very best to help you. You got a chip on your shoulder, but it's not. Sir, give me a minute. I'm gonna try to take you in a breakout room and talk to you before you make your circumstance worse. Just be quiet until you get there, please.
Yeah. Okay.
Thank you.
Mr. Glenn, after you finish talking to him, I'm going to give him a pretrial date for tomorrow. Mr. Glenn has to come into court in person.
Fine. I'm going to the Judicial Tender Commission because you're very impartial. You're not about to try to embarrass me in court like that, man.
Mr. Glenn, stop.
Reading out all
Mr.
those tickets
Glenn,
when we only
let
got
me
3.
just ask you to be quiet so I can help you.
I'm going to file a complaint
That's
today.
fine. You can do whatever you want, but
You're not about to
do
try to
you want
embarrass
my
me
help,
like that
yes
and
or
be
no?
disrespectful to me and think I'm going to sit up and take that.
Mr.
What's wrong
Glenn,
with that? Man, you
Mr.
tripping.
Glenn.
And they come to
Your Honor,
court properly dressed. Don't come to court in a sleeveless shirt. Come to court properly dressed.
Your Honor, can I please have a moment to talk to Mr. Glenn? I muted you because you're not making it better. Just be quiet.
It doesn't matter what you say to him. He's going to take an anger management class too.
Your Honor, I'm going to move Mr. Glenn to another breakout room.
Very good.
He's the Motorola device.
Yes. Move past the matter. Tell him to come to court properly dressed, Ms. Gates.
Mr. Glenn, you should have a prompt to come to go to breakout room 5. Go to breakout room 5. Look at your device, Mr. Glenn. You should have a prompt on your screen to go to breakout room 5. Just click OK. All right, Mr. Glenn, I'm going to send you a different prompt. Just when you see the room number pop up, please just click OK. You're going to room 8.
All right, let's pass.
Just click OK.
Ms. Gaten Robinson, are you still dealing with Mr. Glenn?
Your Honor, Mr. Glenn was not the easiest to try to talk to or get to reason with. He has indicated to me, is he still in the breakout room? He told me he was coming down to the court today. He doesn't understand why he has to come tomorrow, so he's coming down to talk to the chief judge today, which I told him that is absolutely his right. He could. He felt like you were picking on him by calling out his older tickets. I explained to him that that is your process and the process of many judges down there, that when people have outstanding matters, if they are on your docket, you will pull all of their matters in an attempt to be efficient. And you've done that with multiple clients of mine this morning to try to reassure him that that was not you picking on him. He didn't understand why you were bringing up old stuff. So I explained to him that that's you trying to be efficient because he had multiple tickets in front of the court outside of the 3 that were on the docket.
Ms. Gayen Robinson tells Judge Perkins that Mr. Glenn was offended when he called the May 2, 2025 misdemeanor charges along with the 3 misdemeanor charges on the docket, and that she explained to Mr. Glenn that the judge called all the currently pending charges to promote efficient case resolution, also known as judicial economy. The term judicial economy refers to the effective management of court resources to ensure that cases are resolved promptly and without unnecessary work. Here, because Mr. Glenn had a second show-cause hearing scheduled for the following month. Judge Perkins called all of the pending charges in an attempt to resolve all of them in a single proceeding rather than duplicate efforts on a later date.
Third, I called those cases into the record to be as a matter of judicial economy. I don't know when you got those tickets. I don't care when you got those tickets. I try to do that for the benefit of you so you don't have to keep coming back to court multiple times and you don't have these warrants sitting out here on you, okay? That's why I called those cases into the record. That's my choice to do that. And I called the cases into the record for the court and for your benefit, so you don't have to keep coming back to court. Okay? So
I appreciate that.
I'm gonna let you speak. Let me finish. You're gonna come into court in person tomorrow at 8:30. I want you properly dressed. You can say what you want to do what you want to say. If you don't appear, then a lot of people don't show. Third, I called those cases into the record to be as a matter of judicial economy. I don't know when you got those tickets. I don't care when you got those tickets. I try to do that for the benefit of you so you don't have to keep coming back to court multiple times and you don't have these warrants sitting out here on you, okay? That's why I called those cases into the record. That's my choice to do that. And I called the cases into the record for the court.
Judge Perkins reprimands Mr. Glenn for calling him bro and repeatedly interrupting him and tells him that if he continues with this behavior, he will be held in contempt of court. Under Section 600. 1701 of the Michigan compiled laws, judges have the power to punish individuals by holding them in so-called contempt of court when they engage in quote-unquote misconduct during court proceedings, including disorderly, contemptuous, or insolent behavior that directly tends to interrupt court proceedings or impair the respect due to the court's authority. Using a colloquial term like bro for the judge could be viewed as a willful show of disrespect for the authority of the court. Likewise, repeatedly interrupting a judge and talking over other participants in a hearing could easily be considered an interruption to the proceedings. Accordingly, it is certainly possible that Mr. Glenn could have been held in contempt of court for his conduct.
Third, I called those cases into the record to be as a matter of judicial economy. I don't know when you got those tickets. I don't care when you got those tickets. I try to do that for the benefit of you, so you don't have to keep coming back to court multiple times, and you don't have these warrants sitting out here on you, okay? That's why I called those cases into the record. That's my choice to do that, and I called the cases into the record for the court and for your benefit, so you don't have to keep coming back to court, okay? So,
yeah, I appreciate that.
I'm gonna let you speak. Let me finish. You're gonna come into court in person tomorrow at 8:30. I want you properly dressed. You can say what you want to do what you want to say. If you don't appear, then a lot of people don't show up. That's what the court has to say. Now, you want to talk?
Judge Perkins tells Mr. Glenn to dress quote-unquote properly when he comes to court the next day. According to the 36th District Court's dress code, casual business attire is quote-unquote preferred in shorts, cutoffs, skirts, sleeveless shirts, hats not worn for cultural or religious purposes, and now quoting other clothing which is not suitable in a court or any other professional environment is prohibited. Courts can lawfully impose dress codes on individuals in the courtroom. And courts have found that doing so does not generally violate the First Amendment so long as the restrictions are reasonable, neutral, and tied to maintaining the dignity and fairness of the court process. For instance, in the 2009 case of Bank v. Katz, the U.S. District Court for the Eastern District of New York held that an attorney did not have a First or 14th Amendment right to wear jeans and a baseball hat in the courtroom. In reaching this conclusion, the court recognized that judges have the authority to set reasonable limits on the conduct and behavior of individuals appearing before the court, and that they likewise have a duty to maintain the dignity of judicial proceedings and oversee courtrooms in a manner that promotes their integrity. The court also determined that courtrooms are not so-called public forums for the expression of ideas, and therefore that courts may impose reasonable and viewpoint-neutral restrictions on attire such as the 36th District Court's dress code.
So I'm sorry about calling you bro, okay? But I didn't think that you would get impartial and start, you were supposed to be here early. I'm 58 years old, okay? So I'm kind of tech challenged, but I called down and I got in, okay? I was late, but I got in, but it's just the way you was talking to me, that had me like, damn, I don't really want to go in front of this guy here, man. Plus I know Todd, so that's another reason why. Okay, so I was just asking if you could just recruit yourself. Then I found out some other stuff that's something, that's going on. Some news is going on right now. I don't want to be a part of that. I just want to go to another courtroom. If we could do it like that, then we good. Then I don't have to go down to the Judicial Tenure Commission, file a 3-page report. You know what I'm saying? Just recruit me from your courtroom. That's all I'm asking you.
So, Mr. Glenn,
on the grounds of, maybe not because I don't think you're impartial, but
let me finish. Let him go ahead and finish.
Okay. Maybe not because I feel you were being impartial, but let's not say that. But I do know Todd personally. Been knowing Todd for a long time. So that's another issue. Not the other issue about what's going on with you now, but I'm just asking the court, please, just recruit yourself, or just send me to another judge, and I appreciate it.
All right, let me. I'm not going to send you to another judge. I want you to come down tomorrow morning at 8:30. I accept your apology about the bro situation. I didn't hold you being late against you, because I did let you in the room. As long as I'm sitting here, I question why people are late. I understand now why you're late. You told me you're not as tech savvy as other people. And that was it. You also were driving in court. You admitted to that. You have a
so
suspended
let's clear that up. Listen, I have a
No,
business,
it's
and
cleared
there's
up. It's
drivers.
cleared up in the court's eyes. It's cleared up in the court's eyes. It's all being recorded. It's on transcript. You admitted to that. Okay. So let's
say whatever you want.
I let you speak. I let you speak, and I'm speaking. I said, do not interrupt the court. All right. So this is it. We're not gonna keep going back and forth. I'm gonna let you go about your day, but come down tomorrow morning in person. And you can go to the Judicial Commission. That is your full right. You can go to the Chief Judge, but I'm not going to sit here and have you yelling at my staff or anything, okay?
After admonishing him for driving during court, Judge Perkins informs Mr. Glenn that he must appear in person for the hearing the following day. Now, although there is no explicit prohibition on driving during a virtual hearing in the Michigan court rules, under Rule 2.47, 407, which applies to both civil and criminal proceedings, judges have the authority to determine that a case is, quote, not suited for video conferencing and to require any hearing to be conducted in person. When determining whether a proceeding should be conducted by video conferencing, the rule requires the judge to consider several factors, including whether the court has reason to believe that the participants in this hearing will not be able to maintain the dignity, solemnity, and decorum of court while using video conferencing technology, or that the use of video conferencing technology will undermine the integrity, fairness, or effectiveness of the proceeding. Here, Judge Perkins exercised his discretion and concluded that due to Mr. Glenn's decision to drive during the virtual hearing, the proceeding was better suited for in-person adjudication.
Your Honor, listen, Mr. Glenn, please give me 1 moment. Please, I've been begging you since the beginning of our interaction. I'm trying to help you. Just be quiet.
I should have brought my boy Blake in here. I wouldn't have all this.
Okay, so 1 moment, Your Honor. I explained to Mr. Glenn that he does have to be at court tomorrow morning at 8:30. I did also indicate to him that it's his absolute right to retain an attorney. If he is not able to retain an attorney, then he can ask for an appointed attorney tomorrow. Because he is here for misdemeanor matters, he is entitled to counsel. If he wants to pay his own counsel or ask for counsel tomorrow, that is his right. But I'm making it clear that Mr. Glenn is aware of his right to have counsel tomorrow at court.
All right.
If Mr. Glenn come to court, he's coming with all the news coverage. Okay, so we just want to make sure everything is good.
We'll see you in the morning at 8:30. Make sure you look good for the news.
I want another judge, and I make with another attorney.
One at a time. Court reporters.
Put your good suit on. We don't care about you coming with the media. Look good for the media. Put your suit on.
I don't want you. You know what? As a matter of fact, you're on ineffective counsel too. So I'm going to reschedule that.
Have a wonderful day, sir.
Let's handle it like this.
Stop it, Miss.
Have a wonderful day.
Don't say any more, Miss Robinson, please. Mr. Glenn, that's it, okay? I'll let you make your record. Come on down tomorrow morning, all right? Yeah, you're muted. You're muted now. Unmute him, please. Unmute yourself. Unmute yourself. All right.
Let me do what I got to do. Okay. Yeah. All right. Bye-bye.
Some luck to you, sir.
Yeah.
Mr. Glenn failed to appear for the rescheduled in-person hearing the following day, and a bench warrant was issued for his arrest. As of the date of writing this episode, he is still scheduled for a show cause hearing on August 19, 2025. This case underscores just how differently the justice system treats civil infractions and misdemeanor offenses, even when both stem from traffic violations. Default judgments are routine for civil matters, but criminal charges demand personal accountability before the court. Mr. Glenn's repeated failures to appear made that distinction unavoidable, ultimately leading to a bench warrant. The hearings also highlight the court's authority to preserve dignity and order, whether through contempt powers, courtroom dress codes, or the discretion to require in-person appearances when video conferencing undermines the seriousness of proceedings. While some of these measures may seem rigid, they exist to reinforce the legitimacy of the process and maintain respect for the rule of law. With that said, this interaction illustrates the tension between judicial efficiency and a defendant's perception of fairness. Judges often consolidate cases to save resources. But to a defendant unfamiliar with court procedure, that efficiency can feel like overreach or bias. The responsibility falls on attorneys and the court alike to explain these choices clearly so that efficiency does not come at the expense of trust. However, Mr. Glenn's decision to drive during his virtual hearing and his casual confrontational approach to addressing the judge shows how quickly a defendant's own actions can shape the trajectory of a case. Court proceedings demand a baseline of decorum, and failing to respect the court can turn an already difficult situation into something far worse. Let us know if there's a case or coup.
Mr. Glenn, Rondell Glenn?
Yeah, man, I'm sitting out in the sun, buddy. I'm trying to grab me something to eat.
All right, don't drive in court.
I'm not going to be driving, buddy, when I'm in court, all right? Just call me.
No, listen, I'm not your buddy, okay? First of all, but at the end of the day, if you're driving right now, you're not supposed to be driving, okay?
Yeah, but how long am I going to be sitting here? I haven't spoken to no defense attorney.
I don't know how long you're going to be sitting there. You're waiting. If you came on time, you would have heard me. I said I'm going to try to get you out as fast as I can.
It's all good, man. It's all good.
Listen, don't cut me off. Are you driving your car right now?
I'm going to park my car, but man, I can't be sitting out in the sun.
I'm putting you out of the room.
Put me out of the room?
Yes, for driving in court. All right? Come back when you get in a safe location.
Attorney Gaten Robinson, on behalf of Mr. Rondell Glenn. Mr. Glenn, please state your name for the record.
Mr. Rondell Glenn.
Your Honor, I don't know how many tickets that was you just read off. I only have 3 on my docket.
Yeah, Mr. Glenn doesn't have any respect for the court. I see he's exhibited disrespect for the court, and he's. Wait a
minute, hold on, wait a minute. What you talking about?
You wait a minute. You wait a minute.
I'm going to the judicial tender commission.
You wait a minute.
I don't want you to remove yourself from my case, bro.
Listen,
I'm 58 years old.
That's the disrespect.
I don't know what it is about me and you, bro.
That's the disrespect.
Mr. Glenn, can you please be quiet for one? Mr. Glenn, as the attorney who's trying to help you, can you please be quiet for a moment? The first issue that you have is you should not be driving on Zoom. Park the car, please. You cannot drive on Zoom. This is the definition of distracted driving.
He should not be driving at all. He's already indicated to the court that he's driving when he